Welcome to Bridging the Gap, Law, Therapy, and Justice.
Welcome to Bridging the Gap, Law, Therapy, and Justice. I'm Caitlin Burgess, attorney and licensed marriage and family therapist. I work where law and psychology meet, helping families, courts, and clinicians navigate high conflict family law situations with clarity and care. In today's episode, I'm joined again by Jason Wright, founder of the law office of Jason Wright, PLLC in Austin, Texas. Jason focuses on divorce and complex custody matters. Today, we're talking about how online advice, social media, and custody myths are shaping parents' expectations before they even step into a courtroom, and how bad information can create mistakes that become difficult to undo later. Hey Jason, thanks again for showing up for this episode. Thank you.
You bet. Thanks for having me. I appreciate it.
Sure. So I'm sure this is a hot topic right now for family law attorneys, with Chat GPT and Google and all the social media platforms. There's a lot of advice out there. And I guess I'm wondering, Jason, how much misinformation are parents bringing into custody cases today from TikTok, YouTube, Reddit, and other online forums?
Yeah, I would definitely say that I don't know that TikTok or YouTube necessarily, but I'd say the two biggest areas that people come in are AI or ChatGPT or whatever AI platform that they like to use. That's been by far the biggest shift, I'd say, over the last 6 months. That you know when someone has come in and they have been asking ChatGPT, for instance, how to analyze their case, or more importantly, how they'd analyze their other party's behavior or accusations, et cetera, et cetera. The way they talk, what they say, and how they ask it's pretty clear they've got AI. Outside of that, it's the misinformation that really comes from, I would say, is more friends and family. My sister's divorce X, Y, and Z, or my best friend's divorce lawyer said X, Y, and Z, or all of these things that they know of from other people. That's the biggest source of misinformation that we deal with all the time.
Interesting. So, what are some of the most common custody myths you find yourself correcting over and over again in Texas family law cases?
So as I mentioned in the last episode I was with you in Texas, we don't use the word custody. We also don't use the word visitation. So in Texas, we have two things. We have conservatorship, which deals with decision-making power, and then we have possession, which deals with where the children will be. And my phrase, like I say, is you made these things, you get to possess these things. And so the most common myth, I guess, in Texas that I deal with all the time is, men will come in and have I guess men or women will come in and have the assumption that because Texas favors mothers, that moms are going to win. And so that myth that Texas favors mothers is probably one of the biggest myths I deal with from a variety of angles. And what I'll tell you that the reason that's a myth is that what in fact Texas courts don't favor mothers over fathers. It's just that most marriages almost exclusively have a division of labor. Most parents don't sit down and decide, okay, I'm going to do this and you're going to do this. And it just, even my own marriage, there's a natural flow of one parent carrying, even if it's 51% more of that emotional weight or the educational duties or something related to the child rearing aspect, that establishes a status quo. And so when people are walking into my office with this idea in their head that Texas favors mothers, well, really what Texas favors is maintaining as close as they can the status quo of who has been the primary caregiver of the children to this point. And so the issue of, well, one parent has been the moneyed parent, right? I work, I provide, and there is value in that, and no one's devaluing that contribution. But when you're going to a court, and in Texas, we elect our judges, so You're asking a judge who may or may not know anything about family law to decide where the children should live primarily. The default that most judges start with is, okay, well, who has to date before you got here, who's been primarily caring for the children? And in most most cases, I have found that mothers and wives are carrying at least 51% of that weight, and so that's a myth that people have that I have to deal with. In Texas, we do not have a 50-50 presumption, meaning in Texas, it is presumed to be in the best interest of a child that one parent have what we call a standard possession schedule. And i- to give a broad sense, it's not every other weekend. It's the first, third, and fifth weekends. It's one overnight during the week during the school year. If you take it over a 2-year aggregate, it's about 52-48, but it's front loaded in the summer and holidays. And so there's a schedule for us that the person with a standard possession schedule will have less time, less overnights with the children during the school year. And so that is there's every year the legislative session, there's bills and things that people are trying to pass to change that presumption. But in Texas, our presumption is not 50-50. And so one of the biggest myths that people have is if they can agree to 50-50, or if a court will issue a 50-50, then nobody pays child support, and that's in Texas, that's simply not true. That's a separate analysis that has nothing to do with potentially where the children are. So those are probably two of the biggest, um, you know, myths I deal with. Another one that's probably pretty common is infidelity, regardless of which person is alleging infidelity. They want to equate that infidelity to parenting time or decision making power, and in Texas, we're a no fault divorce state. So if you don't like the music your spouse listens to, you can divorce them for that. You don't need a reason to divorce them. But if you have a reason, if you infidelity, for instance, if you can prove that infidelity was a part of it, that goes into a property analysis. It does not go into an analysis for who gets to care for the children. With the caveat of making the assumption that none of that infidelity was, in or around the children, that kind of stuff.
So I guess I'm also wondering, Jason, how do unrealistic expectations about custody outcomes start shaping decisions before the custody case even starts?
They I mean, that's you've hammered in on probably one of the biggest issues that I deal with. What I would say personally, I think I probably weed out clients in a consultation because I'm very direct with my clients. I don't find that it's in my best interest or their best interest for me to sugarcoat things or to tell them things they want to hear just to get their business. I tell them, what they're realistically facing. And I'll tell you, sometimes people don't like that. Sometimes people want to just, have something close over their eyes and be told what they want to hear. And I don't find that to be beneficial to them, their children, anybody. So it is a constant struggle helping clients get from A to B in probably one of the most difficult phases of their life while they're sometimes living in the same house that they are, um, divorcing the person from, right? And so helping them stay on point when an unrealistic expectation comes in, I try to hit those off from day one. And so what happens is sometimes people are human and emotions play into it. And there's a word we don't use in my office. It's not allowed. I correct clients every time they use it. And it's the F word in family law, and that's fair. There's no outcome that we get is going to be fair. And so, it might be reasonable or it might be just and right as terms we use, but it's not going to be fair. And so, helping them, what I call the fair cycle, what happens is they get these unrealistic expectations. They have this feeling of this is not fair or this isn't right. And so now we're over here dealing with this fair cycle when we should be over here focused on, okay, well, the reality is we need to do this or that. And so it can be difficult at times. I think that I find that a large part of my job is helping people legitimately counsel them through this terrible time.
So, why do custody cases, or I guess in Texas we would call them possession cases, uh, Is that what you how you refer to it? Is that the vernacular?
Yeah, I mean, we throw out the word custody when we're talking like that, but, when we're in a courtroom, it's, we're conservatorship, we'd say we're here for, conservatorship issues, things like that.
Oh, okay. I didn't know how you talked about it when you were not in the courtroom, because every single one of my questions is about custody cases, custody. So I'm just going to continue to use it.
People say custody, right? It's something I have to educate clients on too, because some people say, "Oh, they'll say, "I want full custody," or "I want, what's the legal custody," because they've heard that from ChatGPT, or they've heard that from some other source, and I have to like, well, what does that mean to you? Because that doesn't mean anything to the Texas Family Code.
Understood. So when I'm asking my questions, I'm just going to refer to custody cases. I'm going to continue with that. So why do custody cases often become more complicated once online advice collides with the realities of the actual courtroom?
So you're tapping into a lot of my isms. Some of the things I say to clients all the time is that agreements are cheap, easy, and fast, and fighting is not. And so only one person decides anything, and that's a judge. And so when we're moving along and suddenly somebody has either they've read something, saw something their friend told them, or they think it should be a certain way, if the other side doesn't agree, I can't make a client do anything. The other side can't make their client do anything. Now we have to go to a judge. And there is nothing too small that we can't fight about. I mean, from a
True.
property standpoint, I've dealt with $25 gift certificates to the Cheesecake Factory that people spent legal fees arguing about in mediation. When it comes to kid stuff, we can get into the minutia of where they're going to be, and people count. It's interesting to me that when people are married and are living their lives, regardless of how happy they are or what's going on in their world, they're rarely, I can't think of a scenario where they're counting how many hours and minutes they've had solely in charge of the children. But once we're divorcing, suddenly to the minute matters to people. And we start arguing about, well, he gets 8 more hours this week that I got, or whatever. And a lot of that is predicated on where they're getting that information and where they're getting, who's told them, well, my judge said this, or my divorce lawyer told me X, Y, and Z. Every case is different. Every fact is different. And so when you've got information that maybe is true, but what they don't also understand is it doesn't necessarily apply to your facts and your case. And so while the information may not be wrong, it may be correct for this particular case, but not for your case. And so that's how things start snowballing, in that I think clients want they want lawyers to give them answers and say, well, it's 1 + 1 is 2. And law, this, right? If law was math, we probably wouldn't have lawyers. I mean, you can read a book and see, well, yeah, 1 + 1 is 2. I don't need a lawyer to tell me what 1 + 1 is. And so that's a frustrating aspect, but because I can't force them to agree, once we don't agree on this small thing that maybe leads to other things, now the case is getting super complex. We're having multiple hearings. That's how it spins out of control.
Parents sometimes follow advice from friends, online influencers, uh, or other online groups that encourage aggressive tactics early in a case. So, have you seen that backfire?
I try to have little mini coaching teaching sessions with my clients early on. I have a conversation with them of what happens is human nature, right? You get a text string or an email chain between parents arguing, and someone will say something in a text stream that's maybe not true at all, right? Or bringing something up. That time 2 years ago when you slapped me in front of the children. Human nature is to say, she just wrote that down in a text. I have to defend myself. That's not true. And now I've got this text stream of arguments and going back and forth. Um, I tell people, don't accept every invitation to argue. Like, you can just let it go. And that just because she said it or just because he said it doesn't make it true. And so what happens though is people start talking to other people. People go on the internet, or they get upset, and then they start they compound the bad decision with another bad decision, or they take the advice of, they're paying me a lot of money for my legal advice, but I can't tell you how many times they take the free advice from their friend or their family member who knows better or looks something, and now their case has exploded because they did something really dumb uh, that a judge is going to see as being adverse to the child's best interest. And in Texas, that's our guiding principle, and I imagine most states as well. But you know, parents, you're dealing with a primal issue of a divorce, and so they aren't always thinking with the right head, and they make bad decisions. And when they're paying someone a lot of money for legal advice and they don't listen to it, I've seen it go bad a hundred different ways, right? Like, as I mentioned earlier in a previous episode, I think you you can have your possession time reduced. You can have, remember, in Texas you have decision making power and possession. You can have, oh, no problem. Sorry. In Texas, right? You have decision making power and possession. You can have no decision making power and still have possession. Weekends or whatever the possession is, and vice versa. You could have decision making power equal to it and not have very much possession. If the court feels that you're bringing children into adult issues, then you're going to be in a big problem. And when you're listening to people who tell you, right, you don't have to let him take his visitation, or you don't have to let him do X, Y, and Z, and there's orders in place, and you don't follow them, that's bad news. Bad news.
So, speaking of judges, Jason, how do judges typically react when parents appear more focused on winning, more focused on beating the other parent rather than solving practical parenting
The
problems?
short answer is not well. Um, you know, when you're in court, right, by just definition, we are adverse to the point we obviously couldn't agree, right? So now we need a decider to decide. And what I try to get clients to understand is you're going to go ask this judge who was elected, doesn't know you at all, sees 100 cases like you a month, and is going to get to see about this much of your case, right? There's a reasonableness factor. And if you don't appear reasonable, if a judge, what sometimes I'll say, if a judge looks at you like this, like, right, the case is over at that point, right? Because I don't care how much you believed what you were doing, or you felt like you were in the right. When the judge, the decider, looks at you like, well, then they don't think you're reasonable. And sometimes judges have an unfun job of, they got two bad parties. They got to figure out the best worst option. But more often than not, at least for me, I don't like going to court and getting destroyed by a judge. I try to counsel my clients and make good decisions. And if I'm going to go to court, it's for a good reason. And so, when you have a party that is reasonable and appears reasonable and is appearing to be doing things that maybe is adverse to them, but it's good for the kid, right? That whole guiding principle, they can show that I've made decisions to be what's best for the kid, and the other one is trying to justify their position, right? Not taking the kid's best interest in mind, but trying to justify their actions. Rarely does that work. Rarely does that come off well to a judge.
So, social media has made people more comfortable publicly talking about their own divorce and custody disputes. I've seen it on Instagram myself, where people are talking about their situations, very nitty gritty details. Does this create risk, do you think, in your experience during the litigation process?
That's some of my favorite exhibits. You know, when
Okay.
you know people put video up, or put, I can think of a time when somebody made their avatar, on some um, neighborhood group chat, and the avatar was basically a bunch of stuff, very, very detailed and very explicit details about the spouse, but took the position of, I didn't say anything. I didn't go and make a post. I didn't say anything online. They did not go over well. Like, I can count many times when, and I would say the courts are going to look at this like, children can access the internet. The internet is forever. And so when you go and put this stuff on the internet about the children's father or the children's mother, that doesn't go away, and that is not going to bode well because judges are gonna make the connection between your action and how is that gonna affect the child. And, I mean, from a lawyer standpoint, I love it when, the opposing side has those things. It is not good when my client, when a video pops up and I have to turn to my client because they didn't tell me, and they're like, "Yeah, I made that video." I'm like, "Well, we're dead in the water now. That's not good."
So, Jason, can you share an example of a case where bad information or online advice really pushed a case in the wrong direction? Maybe it can't be one of your own personal cases, but maybe an appellate case or something you've heard about, another case.
I'm struggling to think of a specific facts of, this is but in broad sense of what I just was talking about earlier, y when people bring the child into the case in the sense of, bring the adult issues, bring the child in front of that. And I do think that people would I could think of several examples where and it goes back to the idea of posting things online. People think that it's my Facebook wall, for instance. I can post no, it's a public forum and someone has told them you can't get in trouble for that or I don't pretend to know where they're getting this advice, but I can't it happens in numerous cases where people have taken this advice and taken that and made a bad decision or made an action that has brought the child into it or puts the child there's a potential the child's going to see this. And now that parent has restricted rights. I mean, as I'm saying that a case that's really coming to my mind is I had there's a client that um, was convinced that there was an issue and was getting advice from other people of what they needed to do to quote unquote protect their child and was not listening to anything I had to say. And I tried very hard to explain to them, if you keep doing these things, you're going to lose possession of your child. And that's exactly what happened. That person is on supervised access to their child only because they refused to listen to my advice, which again was slow civil litigation. It wasn't getting what they wanted when they wanted it, but they were taking advice from online people and their friends and family and making bad decisions. And now they can't see their children unless there's walls between them.
So, one last question for you here, and then we're going to be wrapping it up. What should parents focus on if they want, rather than focusing on online media? Uh, what should they focus on if they want reliable information and realistic expectations during a Texas child custody dispute?
What I'm going to tell you. I mean, obviously, there's lots of lawyers out there, and there's different kinds. I'm the type of lawyer that's going to tell you the truth, even when you don't want to hear it, even when it's going to make you upset. And I think that finding someone that's going to do that for you is really going to help you and your family moving forward. It may really be difficult in the beginning. It may really not be the things you want to hear and be emotionally hard to hear, but in the long run, that's why we do what we do is to kind of I'm in this business to help people kind of ferry through this really difficult time. And it's not while I enjoy court and going to court is part of what I do, it's exhausting to do that all the time and and to see a client not doing what they can to help themselves and helping their family. And if they're hiring a professional to help them, they should find one that has at least a reputation of telling them directly what's gonna happen, not just echoing whatever their friends have said or whatever's gonna happen and then let happen, if that makes sense.
So telling it to them straight and then having the client actually follow that advice would be your key words of wisdom here.
Absolutely, the second part being a little harder to define, but yes, absolutely.
Thank you. So we're wrapping this one up. That's it for today's episode of Bridging the Gap: Law, Therapy, and Justice. To learn more about my work at the intersection of family law and mental health, as well as forensic practice, please visit my website at caitlinburgess.com. To learn more about Jason Wright and the law office of Jason Wright, PLLC in Austin, Texas, visit his website, jasonwrightlaw.com. Thanks for listening, and don't forget to leave a like, a review, or to share this episode with someone you think might benefit. Thank you again so much, Jason.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.